Hello, everyone. Good morning. Happy sunny Wednesday. The days are blurring together. I'm not gonna lie, folks. I've been up since the sunrise, so now it's like lunchtime for me. So I'm gonna say hello. If this is your first time joining us, my name is Sadie Uribe, and I'm the media producer for the Los Angeles Regional SBDC, and I am so excited to be here with you today. The SBDC is a national program with over 1,000 locations across the country, helping to stimulate economic growth through business advising and development. The LASBDC offers no-cost services through funding provided by the U.S. Small Business Administration, SBA, and from the California Office of the Small Business Advocate. It's your tax dollars at work. The Los Angeles Regional SBDC network operates 7 locations throughout Los Angeles, Santa Barbara, and Ventura counties. Our services are also offered virtually. We are here to help. We empower small business owners by offering tailored solutions through personalized one-on-one business advising, cutting-edge workshops, and comprehensive programs, all provided at no cost. We are dedicated to supporting your entrepreneurial journey every step of the way. Lori, I am excited. A lawyer. We have a lawyer
I
today.
know. And guys, I was making the joke that I've been trying to get a lawyer on for like 3 years. I have a lawyer on, and the lawyer actually showed up too to talk to me. I was starting to wonder, why doesn't any lawyers want to talk to me? Why don't they want to come on the show? But Sadie, I was going to tell you, one of the things, what I love is I love when I open up the chat and I see people checking in my frequent flyers saying hello to everybody. I think that is just one of the most wonderful, wonderful things about the show. By the way, before I get into what I'm going to announce today, I want to already bring up that, guys, I talked about the fact that we're going to have another show happening called Ask an Expert, where we're going to kind of have small biz talk more about interviewing the small businesses, but we're going to have a section where we'll still have our experts on, but we're going to have a show that is just going to be all about asking an expert. Okay, we're going to just start from it. There'll be questions. I think we're kind of talking about it's going to start sometime in July, maybe once a month at first, twice a month. So more details to happen soon. But I thought how fun to have a entire time where we're going to maybe have more than one, a panel. The show must go on. I think I'm a famous talk host now, so I have to keep going. But yeah, I'm getting a lot of responses in the chat. Hey, Sadie, I think they're into the concept. I think they're in. That is
I'm
awesome.
telling you, it's gonna be a win. I can already project it.
I think it is too. So, guys, let me get through what I have today. I'm going to go fast because, hey, we got a lawyer on. We want to get all the opportunity to speak. So, can you believe it's June already? I can't. That means summer vacation, all that's about to happen. But I have my Sole Prop LLC and S Corp, which one and why webinar coming up. This was the legal webinar one, but people didn't understand sometimes legal structure. So I renamed it so people know exactly what I'm talking about. And then my financial literacy series for June. I know I talk about this all the time, but it's so important to know your numbers. So important. Now, I do have a June lineup. I just haven't gotten it all put together yet. So I'll be announcing that next week. But for our last show in May, Johnny from Mantra Coffee is coming on. I met Johnny through the disaster. He had some damage to the physical location. He was in near where the fires were. And I haven't really gotten a chance to uncover Johnny's whole story about the coffee shop, but he's been at it for some time. And so I knew he'd be a perfect guest for the show. So I'm very excited to have him come on. Okay, Lori's Corner. Lori's Corner. Today, and you guys can tell me what you think about what I'm saying here. I want to talk about this question. This question: what is a real company? This question I never got asked. I never got a discussion. I never heard people say this line. Well, I wanted to usually start an LLC because I wanted to be a real company. I've been at this for decades, 3, 4 decades now. And the entire time, I never heard this expression. But now I'm hearing this expression quite a lot. And it's usually in regards to, well, I needed to be a real company, so I hired somebody. I needed to be a real company, so I formed an LLC. In other words, the sentence doesn't make logical sense to me because they're talking about an action that should be contemplated for many different reasons. I have a legal concern and I've looked into it, and an LLC makes better legal sense to me than a sole prop. Okay, that makes sense to me. Wanted to be a real company, so I formed an LLC. Financially, we're growing and can afford to put an employee on, and we did a financial analysis. That makes sense to me. Needed to be a real company, so I hired somebody. What I usually find is because there's no solid foundational analysis behind this decision, the decision doesn't even warrant taking place. So after it's been said so many times over the last couple years, I've started responding to people. What does that mean exactly? And I realize that it's part of the programming, one of those words I use a lot, conditioning, that the media, social media, outside, people tell others, and they tell entrepreneurs in this case, almost as if they don't count if they're not a certain legal structure, which, like I said, once again, makes absolutely no sense. And I even had somebody say the ultimate, well, I haven't made any money in the last 3 years and I want to be a real company, so I'd formed an LLC. Well, that is really illogical. So I want to invite you to reconsider what a real company really is. Because I said, I know people who have multi-million-dollar companies. They have debt galore and they're not making a penny. Is that a real company? I know people that are sole props, working out of their home, selling their services, making over 100,000. Is that a real company? I can't say a real company is because of employees or its legal structure. But what I can say is when someone is engaged in a business and it's providing them income to pay for their necessities, the Maslow law stuff, and also giving them discretionary income, and they're happy, they're enjoying it. That to me is a real company, guys. So stop listening to these outside social media people who are telling you to make business decisions based on some weird statement about whether you're a real company. In fact, I talk to you guys all the time. Get rid of that nomenclature. It's just another way to say to individuals, human beings, you're not enough. You're not perfect. Guys, you're enough as an entrepreneur. You're perfect as an entrepreneur. You're growing, you're learning, you're experiencing, you're trying, and you're failing. That's what it means to be real. Okay, that's from Lori's Corner today. So, with no further ado, I am very excited to introduce Nadine Bedwan. Nadine started Citrine Trademark Services out of a deep respect and passion for entrepreneurship and the creative journey. She uses her thorough understanding of trademark law to help brands and businesses avoid legal pitfalls, secure their identity, and grow with confidence. Citrine was born from Nadine's desire to help artists and creatives legally protect themselves in a business world. Nadine, welcome to the show. I'm so glad to have you here today. You actually, but the first lawyer after 3.5 years. You are the first lawyer to come on the show. Welcome.
Thank you so much. I'm so excited to be here. I've actually done some work with the SBDC before, so I'm really excited. I've been wanting to be on this show.
I know, because I think you came through Myra, right? She said, I think the
Yeah.
email came through, which she's always giving me wonderful people. She gives me a name, I'm like, that's it, they're on the show, they're on the show. So Nadine, what I always like, because you're an entrepreneur as well. You're one of the
Yeah.
fellow entrepreneurs here, and this show is all about entrepreneurs and their journey. So did you always know that you wanted to be a lawyer? A lot of times lawyers do always seem to know they want to be a lawyer. But give us your background and in your progression into then starting your own company or whatever you're involved with Citrine Trademark Services. Tell us the story and the
Yeah.
story.
For sure. So I think I wanted to be an entrepreneur before I ever knew I wanted to be a lawyer. Growing up, my dad was always an entrepreneur, and it just always made the most sense to me, even though he's never had the easiest path. There have been ups and downs throughout my life, but it just always made the most sense. Like if you're a hard worker, if you have passion, that you would put that towards your own thing rather than towards somebody else's thing. So I always wanted to start my own business and work for myself. I did not know that I wanted to be a lawyer until actually I was out of my undergrad. I studied communication journalism because I've always loved reading, writing, analysis, just words, like a general love for words. Um, and then I kind of reached this point where I was like, okay, what am I gonna do? Like, I don't feel like I have that drive for journalism. And then something just like popped up in my head of like being a lawyer. And then I just could not shake it. I couldn't get rid of it. So I joined law school, but I always had a really creative side and wanted to kind of feed that and be a part of the arts. And so I was always drawn to intellectual property as soon as I entered law school, and that trademark and copyright fall under that, which is what I do essentially. And so I graduated law school. I took those classes, loved them, absolutely loved them. But it's super hard. I'm in LA to find IP-based jobs because it's very connections-based. A lot of IP is tied into the entertainment industry. So if you don't know anyone already doing that, it's really hard to break into. So I ended up doing civil litigation. But in the back of my mind, I just like had this vision and kind of like started to reverse engineer it. Like, I know I want to have my own firm. I know I want to do IP. And so just one day I kind of hit a wall at my job. I was like, I really can't stand this. I don't like what I'm doing, but I know I'm a really hard worker. I know I'm really responsible and capable. And then the steps kind of fell in front of me, like one after the other, to start my own firm. It was kismet, I guess, if you believe in that kind of thing. And so here we are.
You know, that is a beautiful story, and there's so many takeaways, and I hear it a lot in interviewing guests. The first thing is what I loved about it is the convergence of all of your passions, abilities, and skills. Your desire to be creative, your hardworking, your analytical, and you know what else I found fascinating is I don't think I've talked with other lawyers, not like I talked with a ton of lawyers, but over being a CFO and banking and turnarounds, I've had my share of, lawyer associates and lawyer dealings. I never met anybody that actually had a communication and journalist background, which I have to believe has really benefited you and mostly your clients, because most of the lawyers I speak with can't communicate.
I don't know if it's the degree that benefited that or if it's just kind of my values and who I am, but I think a communications degree is very much geared towards like marketing, at least at my school, UCSB it was. And so I kind of find myself wishing that I paid more attention now that I have my own firm and I'm having to like market it. And I'm just like, oh my God, what was I doing in those classes? Because that's been like one of the biggest challenges for me for sure.
Yeah, absolutely. And it is for even those that have a marketing background. It's so true. I had somebody just yesterday, I was speaking with them and they were like, I'm going to start, I'm going to be an entrepreneur. I'm like, but you have to get clients. They kind of forget that part that you have to
Yeah.
get clients. Absolutely. And the other part I loved about your story, and it's so true with so many of us, we end up going down these pathways trying to figure out what we're going to do, and it doesn't quite feel right, it doesn't quite sit right, and then suddenly whatever happens, it's always different, but there's this trigger that says, okay, this is where I want to go, and then the doors open up. But it's so evident afterwards, although it's frustrating in the process, that all those steps benefited and helped you to have the background and
Yeah.
experience to where you are here. And I think that's a lesson that I always talk about, because so many people, especially the younger ones, that are right out of school, they're like, I got to be an entrepreneur right now. And I'm like, those pathways lead you to a
Yeah.
lot of understanding.
Yeah, definitely. I think the biggest adjustment as a lawyer is when you're at a firm, any question you have, you can go to, your supervisor or the partner's office right next door and just ask them. When you have your own firm, that's taken away and you've gotten so comfortable kind of having that safety net. I think where I was, they did a good job of like weaning us off of that pretty quick, and just telling us like, you know the answer, like go back to your desk. And so now, I mean, I have a network, I have mentors, but obviously you can't go to them like with every little thing. And so just having that trust muscle built up over time from not being an entrepreneur, but having kind of more of a safety net than I do now was definitely really helpful. I'm super grateful for that.
I
Even though
love that
I
expression.
hated it.
I love that expression, trust muscle. That is so true. And I ran into the same thing early on too, because I was doing turnarounds on myself, right? And going into companies that were in financial trouble and figuring out how to turn them around using my banking background as well. And I didn't have anybody to go to ask, and I had to rely on my own ability to research and find answers. And it's a lonely place, but it's an
Yeah.
empowering place, and it's where entrepreneurs live all the time.
Absolutely, yeah.
Very much so. So now let's talk a little bit about the trademark, and we'll get into the copywriting in a bit. But you focus, which we were talking before the show, in my belief, one of the hardest industries for trademark, but it's the fashion and apparel. Although it kind of follows through with other industries. Tell us a little bit about anything to share with the fashion and apparel. I know you probably chose that on creativity, but elaborate on it. And I'm sure that there are challenges, especially with trademarks within that industry.
Yeah, so I mean, trademarks across the board function the same way. I think have like focusing on an industry that you have some pre-existing like knowledge of, passion for, interest in, it's going to make it easier for you because like when it comes time to talk to your clients, to strategize their future trajectory with them, to describe the goods and services in the trademark application, I'm building off of something that I already know. Whereas I've worked with accountants and people in biopharmacy. And that for me is much more of a challenge because I'm having to almost like learn at least some surface level about that industry on the spot to be able to give them like as comprehensive of service as I can. Whereas I chose fashion and apparel because I kind of have like a pre-existing knowledge of how the industry works and these sorts of things because I have a pre-existing interest and passion for it. So it doesn't seem very difficult for me as much as anything else would. And the concept of trademarks across the board, whether you're doing food, whether you're doing fashion, is going to be always the same thing.
Yeah. And it's interesting you mention it, like biotech and stuff. And I've worked with a lot of scientists over the years as well. Part of it is that I had a 2-year biology and science, so they saw it as this ability to understand finance and science together, which sometimes I've had worked with scientists at JPL that I understood what they did in their complicated business model within 5 minutes, where if some people are just selling widgets and they go on for 20 minutes and I still don't know what they do. That's kind of the
Yeah.
joke. But I get what you're saying. You would have to fully understand all of the mechanics in it,
Yeah.
and that would be quite complicated. Okay, so here's where we're going to go to an interesting question, and it's specific for our younger entrepreneurs, right? And so here is a personal story. I don't think I haven't told this story too much, but I think it'll be a great introduction to the question. And Nadine and everybody in the audience, go ahead and laugh at me. Okay, you get to laugh at me with this story. Okay, let's go back to my young entrepreneur days, right? Probably in my 30s, maybe something like that, where I've been in the game long enough to just be enough arrogance and belief I can do everything on my own, right? So I had the name at the time, which I still do, Business Simply Put. And of course, like I hear many say, which I have to laugh at myself, I had this belief, Nadine, that everybody in the whole world was going to steal Business Simply Put because my ideas were so unique and great that I had to do everything to protect it, right? Okay, now I'm already spoiler alert thing. Well, that was kind of stupid. Like nobody really wanted that name, but I believed it just like people believe it, just like they say to me, right? So I went ahead and on my own, I did the trademark thing, filed the documents. I'm like, hey, I can read legal. I know finance, right? So I filed these. Eventually did get the papers filed. And then, because I was able to go through a couple rounds and got the trademark. And then I thought, oh, I'm so cool. I got my trademark right. Well, it gets worse, Nadine. So I Googled names all the time, and somebody had some other name that was something business and a put or something. It wasn't even close enough, but I then decided on my own to do a cease and desist and cease and resist, what am I trying to say? Letter. And yeah, and I sent it to them, and this poor like one-time entrepreneur, this young entrepreneur in New York, ended up taking her website down. And I was like, see, I did it. I did it, right? I was so proud of myself. Okay, Nadine, fast
Yeah.
forward 10 years later, I was thinking about that. Yeah, that's what I was trying to say, Chris. Cease and desist. I couldn't get those words out. 10 years later, here's the conclusion. I thought about that again. And you know what I thought about? I'm going to tell you the true words, okay? I said to myself, Lori, you were an ass. You were a
Mm.
complete ass because I went through all this to save something that really didn't even need to be saved. It's me. It was stupid. I didn't even need a trademark. And this poor woman on the other side of the country that was operating probably went through the expense of taking a website down when it really didn't matter, right? But I was so convinced at that age, Nadine, that I had to protect this name because I was going to be the greatest thing since sliced bread. I think that's a really good story to launch into when we as entrepreneurs need to worry about a trademark. Because Nadine, on a daily basis, literally, I get people, I just thought of this idea, I got a name and I want to get a trademark. They don't even have a business
Yeah.
created yet, and they're already trying. And I know enough to say you got to use it a bit. So I am turning the entire stage over to you now, having shared my soul of my own ego and stupidity. And you can laugh and comment on that, but take us anywhere you want to with that story and that question.
Sure. So I can sense the youthful ego in the story, but I don't think it was stupid. I think actually like that drive of, this is going to be the greatest thing since sliced bread and I want to protect it is how I think any entrepreneur should think when they're starting out. Why would you not? Why would you, start a business or start a passion project and not think it's going to be the greatest thing since sliced bread? So I really do love when people have that attitude. I think, yeah, that poor woman who took down her website, I think whether she actually needed to or not, and whether you had grounds to send that letter is going to depend on a couple of things, but ultimately, I guess it worked out in your favor. So just to touch on that, like the point of trademarking essentially is to cut down on what's called the likelihood of confusion in the marketplace. So if her name was similar enough and what she was doing was similar enough to what you were doing, that people would likely get confused between whether the two of you are running the same business or related in some way, then she was potentially infringing and you did have a right as the mark holder to stop her. So it's not that crazy. I mean, it was very brave and bold, but I respect that. I think when it comes to like when is the right time to file a trademark, so like you said, you do need either to be using the mark or what's called a bona fide intent to use the mark. So you can't just own the name for the sake of owning it. You have to be doing something or plan to be doing something in the near future with it in a commercial or a business sense. It doesn't always have to be something that's going to create revenue. Like it can be a video series, it can be a blog that people aren't paying to read, but it's still like something of a, I guess, business venture because there is kind of like blurry lines, but you do have to be using the name essentially in
Yeah, Nadine, can we talk about, yeah, and so what I had already been doing seminars, so I had flyers, I had all
yeah.
that, so I was able to improve on that because I'd been doing it for some years. But I know that they also say plan on using it, and that seems like such a vague area. Like I plan on doing it. That reminds me of
Yeah.
Texas where we go fixing to, we're fixing
Yeah.
to the rest of our life. So how does one prove plan to?
Yeah, so you can file what's called an intent to use application, and that's a really good thing for if you're planning to launch this business, but you don't have any like landing page to show, you don't have any sales yet. And when you file your trademark application, what this hinges on is something that's called a specimen that you need to show as part of your application to the USPTO. And what that shows is that you are actually using the mark in connection with the goods and services. So another part of the application is you have to describe, and there's these things called international classes. So there's classes for clothing, food, beer, wine, liquor, like anything you can imagine will fall into a class. So you file pertaining or under specific classes, and then you have to show the specimen proving that you're actually using it. That could be a photo of your like item on the shelf at a store. It can be your booth at a farmer's market. It can be your website checkout page, anything that just shows you're using the mark. When you file an intent to use, you don't have to submit the specimen right then and there with the application. You have a 6-month grace period essentially and then they'll ask you for it. So you have a little bit of time. And even that 6 months, you can extend it a number of times to where it ends up being about 3 years. So if you're going to just apply and sit on it, then you're gonna run out of time eventually before or until you can show that you're using the mark. And if you never end up using it and being able to show that, then you're going to lose it. But you do need, when you file even an intent to use application, you need to know what you are planning to use it for, because they're going to ask and you're going to have to show it eventually. So you do have to be somewhat in the planning phase, not just like willy-nilly.
Gotcha. And then to kind of create a foundation, and this is part where I'm asking the question with confusion, so I may not even be asking it correctly, but I do understand just enough to know that there's, people say, okay, I'm going to get a trademark, and then they think it's an international trademark. That's a whole different animal. But I think it's also, and this is where I'm a little vague, I could be wrong on this, Nadine, it's also a state trademark versus a United States. Like there's a coverage type situation, if I can call it coverage. Can you talk to our audience about that?
Yeah, so what my firm does is federal trademarks. That's the most common type and also the most protection that you're going to get. I think people use state trademarks. They don't offer as much protection, and I don't really see the point in them unless you are working in an industry like, for example, cannabis, where it's not federally legal, but you can have some protection on the state level. Otherwise, you should definitely go for the federal trademark, because the state trademark's not really going to hold a candle to a federal mark holder if you guys do have competing marks. And all trademarks are federal. All federal trademarks are federal, not the state ones, but they go country by country is what I mean to say. So if you have the US trademark for a certain mark, that's not going to hold any weight in Canada or in France or Mexico or whatever. You would have to file separately in each country. And the mark that you have here in the US can serve as a basis over there, but it's not going to guarantee you that that one's going to be accepted, because they have their own competing marks already on the market that could potentially block yours. So I think for most people, my recommendation is definitely to start with the US federal trademark. And then as you build more of a presence in another country and it becomes more important for you to protect and own the name there, then think about it or pursue it, because it is costlier and it does maybe take a little bit more time. There's also companies, that go by different names in different countries because they weren't able to get the trademark there.
Gotcha. Well, and this all makes sense because going back to my story, in my unknowing of what was doing, I set it up by state. So when I sent her a letter in New York, I didn't even really have jurisdiction, which I didn't understand till later. But then I started wondering, why would somebody only want to do a state? And now I think with the internet, it really makes it even more questionable. So
Yeah.
I get that now. So when somebody like a brand new company, and I know don't want to like pin you down on cost or anything to the degree that you're able to, but people have to decide things like, should I start a legal structure? Should I do this? What can we tell an audience that maybe has a trademark and shouldn't, try and decide, do I put the money towards that? Do I put the money towards marketing and getting clients? That kind of trying to
Yeah.
prioritize, because pretty much everybody that's listening right now has what we call scarce resources.
Yeah.
Okay. So can we talk to that in any way?
Yeah, so there is for sure like a catch-22 or like a dilemma when you're starting a business and you don't have that much traction, but you're scared if you get more traction, you get that visibility, you're opening yourself up to potential copycats and vulnerability, and you don't have protection and you want to know where to allocate your resources. So I always tell people, like, first of all, when you know you need a trademark is when you can answer yes to both of these questions. Like, the first one is, do you know for certain or feel very strongly that the business that you have now, what you're selling, what you're doing, you're passionate about it and you know that you're in it for the long haul? It's not like let's see if this works out. Let's like play around with it for a little bit. It might change. I don't know, that kind of thing. If you're like, no, this is what I'm doing and I'm moving forward with it, first tick. Second is if the name that you're currently using and operating under is the name that you want to move forward with, if you feel strongly that, this encapsulates what I'm doing, the vibe, the energy, it resonates with my audience, it resonates with my brand. If you can answer yes to both of those questions, I think a trademark should definitely be a priority. And then, I mean, and then there's, there's people who are like, oh, this name is a placeholder. I don't really know if I'm going to move forward with this. Then don't get the trademark because it is an investment. And there's no point if you're still kind of wishy-washy about it. In terms of investing and allocating in marketing while getting the trademark, I always say to spend very conservatively until you actually have the trademark. So don't, blow through your entire marketing budget on a name that you don't know if you own it yet. So, get the lower priced packaging, focus on like flyers, maybe not a commercial or a billboard or something that's gonna, like get the word out more conservatively until you own the name and you have the revenue to go as big as you want. Because once your name is really out there and there's more visibility equals more vulnerability. So you want to be conservative, A, to save money, and B, because you don't really own the name yet.
Gotcha. Now, when we talk about the trademarks, I get asked this question a lot, and it comes in all different directions. They may be concerned that they don't have the website to match what their brand name is. And so how important it is that for the entire exposure to all be under that same name versus maybe just the name of a product.
Yeah. Well, you can get creative with like the domain name if let's say your business name is XYZ. I don't know. And that domain is taken. A lot of brands get creative. They can do like XYZ and then like clothing or XYZ and then like some kind of descriptor of what they're actually doing, and kind of add more to it that way, or get a little bit creative in the domain where it has the mark or the trademark name or the brand name, and then a little bit something else to make it like a little more creative if what they actually want is taken, which sometimes does happen, but you don't need it to be uniform for any legal reason. It's more from a branding standpoint, and there's ways around that.
Yeah, and that's why I was asking because people were concerned that they couldn't get the website and everything to match. Now, we got a question from one of our frequent flyers, Brenda, and she's asking about a generic logo that you purchase. Does that need to be trademarked? Nothing really needs to be, or what do you feel about, a generic logo versus a logo that somebody completely customized? I asked Brenda what she meant by generic logo, and she said one that anybody can buy. But then I think possibly you couldn't trademark that. So I know that there's probably some spinning around in circles with that question, but let's ask it, and I can always get Brenda to give us some more clarification.
Yeah, so it would be hard to answer without kind of seeing what the logo is because generic is actually a trademark term. There's different classifications of names and logos that you can trademark. And on the more creative end, they're going to be much easier. Whereas on the least creative end, which is where you get descriptive and generic, they are difficult, if not impossible, to trademark. So I would have to see
Yep.
because
We all couldn't
normally
make
when I think of these descriptors, it's talking about the name, not the logo. But yeah, if it's already being commonly used or if it's not creative enough, typically you're not going to be able to trademark it.
Gotcha. And if you have a name that you're trademarking and you have a logo and they're different, do you have to trademark the name and the logo, or do you trademark that as a set? How does that work?
So they would have to be separate if you are wanting to protect them separately. If you do it together, then you're only protected as when they appear together. So you would
Ah,
have that use very, very consistently across all your platforms and all of your marketing.
yes, that makes sense. Didn't even consider it. Okay, I was going to wait till later in the conversation to ask this question, but it's already coming up, right? So we talked about it beforehand because I didn't want to ask Nadine a loaded question and she'll never come back on my show. But you guys that have been here for a long time, every single time I've had somebody on marketing, you always say, well, what about copyright if AI takes it? And
Yeah.
we just got a question from Monica. What if the logo's created by AI? I know the jury's still out. We don't have precedents. It's still a gray area, but what can you tell us about AI creation, copywriting, protecting, anywhere you want to go on that?
Yeah. So, let me talk about like the copyright attachments to the logo that you're trying to protect.
Okay.
So, when you protect your logo, you are basically claiming it and owning it in relation to using it as the source of your good. So using it as a brand signifier for your brand. But people will grab logos from many different places. So if you have like, I mean, if you Google image searched, which never do this, but if you Google image search, like describe the logo and then you find something and just drag and drop it and try to trademark that, you know, you don't know where that image came from. You don't know who the artist is, who owns the copyright, because once you create a work of art, copyright attaches to it automatically. So you don't know who actually owns the copyright or the artistic license to that image. And
And
if you,
I don't want to interrupt, but when you said that, I want to make sure our audience gets it. When you create an art of a work, I don't want to repeat wrong, but I think, that was such a key point. We went fast. I want that to stop so audience gets it. When you write something and when you draw something, there is some form of copyright naturally attached. Can I say it
yeah,
that way? You explain it
yeah.
properly.
Yeah, so let's say I, write a poem on a piece of paper right now. That there is some copyright that attaches to it. Now, whether I'll be able to prove that in court is a different story. If you are serious about protecting something, you should get a copyright registration for it. But just generally speaking, if you put out a work of art on the internet or whatever, and it is traceable to you, you do have copyright protection over it. And like we said, like with the internet and how it works these days, you can trace things back. So you don't want to use other people's work basically because you don't own it, they do. And you can get in trouble for that legally. So that's just to say a lot of sources that we can find images from online and try and use them and copyright them, even with the best of intentions, you can get in trouble for it. So it's important if you're using something like Canva or like free designs and designing your own logo, go into the terms and services or even ask like ChatGPT or something like who owns the copyright on Canva. I think with Canva, they retain it, I think. And then when you go on these like logo designing websites, certain ones have different rules. So it's important to know where it's coming from. If you hire a freelancer off like Fiverr or Upwork, with freelancers, you have to specify like this is going to be my copyright, not yours, that kind of a
Right.
thing. So that's something important to keep in mind for sure. I think with AI, so I know there's like a Wild West kind of thing with AI. What I assume you mean is if, let's say, I go into ChatGPT and I say, like, can you design a logo for me? And then kind of do like a description of what I want. I think for now it's fine. Because obviously, you're putting in the prompt, like the prompt is you're kind of using it as a tool, let's say the AI. At that point, it's like the pen in your hand, but you're generating the idea. I think, like I said, there is kind of like a wild frontier. We don't really know where it's going to go because things are kind of evolving in a way that we never did. Like copyright protection was never meant to protect your style of drawing, but now with AI, when we're seeing it with Studio Ghibli, if anyone's familiar, there's this kind of like trend on AI where you can put in your photo and it'll kind of Ghiblify it or give it back to you in this like anime style that's typical of this one specific studio. The studio hasn't sued, but people are like wondering what the implications of that are because obviously they're not happy about it, but they don't have any legal course of action. So we don't really know how it's going to advance. Right now, it is limited. Yeah, it is limited, the like copyright protections over AI. So there tends to be more you can do with it than I think there will be in the future. But I think just, yeah, be careful. And yeah.
You know what's interesting? It just dawned on me with AI, you have to be a technology expert as well. Like all the different, it's Canva and stuff you're talking about. Canva's well known, but these others that you're talking about, you have to stay on top of all of that type. You know what? You said that I find totally fascinating. I am very familiar when you hire a freelancer to create anything design wise, you have a contract saying I own the copyright. Totally familiar with that. I did not know that some of these tech sites have in it that they own the copyright when you go on and create it. I don't think most people would even have an awareness of that. That
Yeah.
is fascinating to me.
Yeah, so it's important just to, check what you're using, like their terms and services. And again, if it's like a lot of dense legal language to look through it, just copy and paste into ChatGPT and ask like what did they say about like who owns the copyright in, this case, whatever. Just describe kind of like your situation and it can usually give you a clearer answer.
Well, you know something I've always wondered, and once again, I'm going to take the Wild West and go even more Wild West on this one, Nadine. But I know and I believe so. Once again, I'm not an expert on AI in any way, and I'm not an expert on copywriting in any way. But one of my thoughts that somebody has asked me several times as well is that with a lot of the information like Chat GPT is collecting from in the internet, in the websites, etc., it's actually being a copywriter itself. It's taking, it could go to my website. I worked so hard to make my words perfect. It could read my website, I'm believing. And then somebody could ask a question, and unknowingly, it is stealing from me. So AI stealing from me. I could be crazy and that doesn't happen. So you please correct my notion. But I'm thinking, well, what about AI stealing? Because it's really, to me, just regurgitating what's in existence. It's not at this point, in my understanding, at least the AI I'm around, creating new, it's regurgitating. So what's in existence is owned by someone else that it's regurgitating, if that makes sense what I'm saying.
Yeah, and I think I'm not an expert on this, but I have seen enough to know that I think that certain publications, like, don't quote me, but I almost want to say the New York Times was like suing OpenAI. I don't really know, but that is the concern, is that, their articles that live behind a paywall are kind of being used to inform AI, and people are getting the information anyway.
Ah.
So yeah, I mean, it's the Wild West, but
Well, you just have to say, guys, what a great time to be alive. It is an
yeah.
interesting, fascinating time.
Yeah, but I think the point of the law is always to adapt with the times. I mean, we've seen it happen with social media and with, coding and computer algorithms. So this is nothing new. And property law, or intellectual property law at its core, is based off of like real tangible property law. So it's always the same principles that are adapting, and it's exciting to see how it's going to adapt to what we have now.
In that, does trademark law, copyright law depend upon precedents to the degree that other law does, where it's all new precedents being set that's going to determine the interpretation? Or does it have an old standard rule book of trademark law that just kind of, always is dusted off?
I think copyright is more prone to like adapting and being consistently molded, whereas with trademark, there's less opportunity for that to happen. And so you do kind of like the rules that existed are kind of the ones that carry on. There's not as much space, or at least I can't really think of an example in like recent times where it had to, do this drastic turn. Whereas I know in copyright, we've seen with the advent of the internet and social media, like one of the elements that you had to prove was exposure. Like if you're saying someone's copying you, you had to prove somehow that they would have been exposed to your work. Whereas now that everyone sees everything, that's less of an issue that we see. So I think copyright more so than trademark, but theoretically, everything in law does have to change with the times.
Yeah, that's
It, yeah,
fascinating.
but
So
it moves
that
at a snail's pace, no matter what.
Yeah, yeah, it does. It's always trying to figure out what the law is going to interpret in the new
Yeah.
situation as it exists more than once. Then they're like, okay, we better figure something else out here, which takes us perfectly to the next question. So say I do trademark. I do know that, my little writing my letter, and that's not the norm. That was my, fun little story, but it was true. But there is a cost then, I'm assuming, to go after people who infringe upon it. And I know that that's the biggest discussion all the time, even when we talk about international. Okay, so you find them, what are you going to do? How can you enforce it? So can you walk us down like any kind of detail to just overview of what happens when you want to enforce it? Because somebody, I'm thinking small company, may be able to afford to get the trademark, maybe doesn't even have anybody use it, but even if they do, can't afford the enforcement.
Yeah.
So how does that all work?
So let me just start by saying, even if, you can't, well, okay, I'll just answer. But basically, like when you have a trademark, even without the enforcement aspect, it's still worth it to some degree, because you are standing your ground and ensuring that you're not infringing. So nobody can come after you, which is also another huge point, because if
Okay.
yeah, like you don't want to have like there's huge costs associated with accidentally being the infringer. So one half of having the trademark is ensuring you're not in that position. But let's say you do want to go after somebody. A lot of people ask like, okay, if I have the mark, how do I know? Or how will I know if anyone's infringing? And a lot of times, if you are a smaller business and you don't have people hired specifically for the purpose of making sure and surveying that there aren't infringers, you're not going to know until you encounter them in the wild. And a lot of times you do, because people like your business can't grow to a certain degree, especially within your industry, without other people being aware of it. So eventually you do catch wind of it. And a lot of times that is how it happens. And so if you want to go after somebody, the first step would be to send a cease and desist, typically through an attorney. A lot of attorneys will do this on kind of their hourly basis, their hourly rate, as opposed to a flat rate, which a lot of trademark work does work on a flat rate. But with cease and desist, it's unpredictable to know how long it's going to take if, let's say, they retain an attorney to respond to you. And then you kind of have to engage in this back and forth, and you don't know if they're going to back down or if it's going to require more. So you'll usually be paying the attorney's flat rate for that. And it really could depend. And it depends on how far you want to take it as well. Sometimes you'll settle and relatively quickly, or sometimes they'll come back and, try to argue before you want to take it to the trademark trial and appeal board, which is like the trademark's version of litigation. And so if you want to go further and go that route, it's going to be a lot more expensive, obviously, to protect yourself, as opposed to if you were to settle and say, okay, you can use it in this very limited capacity, or if they back down and pay you money and it's a done deal. But it really, really depends. I know that's the
No, I would
quintessential
expect
attorney
I
answer.
wouldn't expect any, black and white, because this is all on, it depends. But you know what I found fascinating, which I would have never even considered, is having the trademark to show that you own it, so no one else can come at you and say that you are infringing on someone
Yeah.
else. That's an angle that I hadn't even considered till you said it. So I wanted to
Yeah.
bring it back up because I think that's a fascinating aspect as well.
Yeah. And so that in itself, like you have to wait even after you have the trademark to get to that point. So you can think of it as when you first get the mark, it's like the clay is very wet and it's still kind of susceptible to attack. There's a 30-day period where your mark, every 30 days, they publish something called the Official Gazette, and all of the new marks are in it. So that's why I was saying people can hire someone to look through the Gazette every month and let you know if there's anything similar to yours. But when you are in that Gazette, it's very easy for somebody to see it and challenge your mark and be able to, raise an issue with that with the USPTO. And you don't have all of the fully fledged rights yet, because like I said, the clay is still very wet. After that 30-day mark, it hardens a little bit, but you're not going to really be like uninvincible until 5 years. So
Okay.
once you reach 5 years, you can file this form called it's like a section 15 incontestability form. And once you're incontestable, then it's like nearly impossible for someone to try and shut you down. But once you have the mark, that is a huge milestone, but there's still like a little bit of a ways.
Interesting, interesting. This is so great because I get to ask these questions that were asked of me that I didn't even have a clue. So I had one person asked this and then another person asked it. They were setting up a website in their case to sell other people's products. That's what they were doing. But I've also had other people that distribute other people's products, right? And, a lot of people in California are not manufacturing. They're basically buying finished goods and distributing them. Their question is, what if they have somebody that they're selling the product and someone else comes back after them saying that that was not their customers, basically, trademark. And I said, I don't know if it can pass on responsibility to someone that's just providing a selling platform, because that's what they're doing. They're providing a selling platform, that I don't know if they have to be concerned to that. Of course, their question was in relationship to, I'm going to create an LLC and that would protect me completely, which I had to say, no, it wouldn't. That was my answer on that. There's more involved, but I don't know if it can be where everybody gets dragged into the lawsuit, even the selling platforms for the products that maybe have a trademark question. Does that make sense, even what I asked?
Yeah, I think there's a lot of opportunities to get into messy territory, but Like, so when I think of a resale platform, I think of like, the Real Real or Poshmark or whatever, that sell, other brands in fashion. A lot of times it's secondhand. So if you're operating that platform, all really you need to worry about is having the mark for like your brand name. So if I owned the Real Real, my mark, my brand is the Real Real. I only need the trademark for that. You don't necessarily need to ensure that everything that passes through, I mean, yeah, you want to, I guess, make sure if you are the Real Real that you're not selling infringing goods because you're representing that everything is authenticated, obviously. But what I mean to say is you're not responsible for each and every mark that passes through your marketplace. I think if you realize that something is infringing, you might want to stop doing business with whoever that person is that's providing the infringing products or goods. But if they ultimately don't have a trademark for their products and somebody's coming after them, that's kind of on them. You as the third party seller can choose to cut off business with them, but I don't think that would open you to any liability unless you're making representations that would then be like false advertising.
Yes, that makes sense to me. And that's kind of what I thought. So thank you for that. Let's talk about the industry you're so familiar with, the fashion industry. And what have you noticed? Like you've been at this for a while. What are you seeing as far as trends in trademarks? Are more people getting trademarks? Are things more difficult? I don't want to put any words in your mouth, but just kind of give us an overview of what you find interesting, what's unique, what's consideration specific to that industry and trademarks.
Yeah, so I think something that is unique to fashion, well, it's again, like a lot of trademarks is the same across the board, but something that people in fashion can take more advantage of than might be as obvious in other places is so when you think of a trademark, a lot of times you think of the brand name and the logo, and those are the main signifiers of the source. Because really a trademark is meant to be the signifier of source, so that when somebody sees it, they think immediately like, oh, that's so and so's brand. Like I have a hydro flask right next to me, and it has that little like person kind of in a star shape. So like as if I saw that anywhere, my mind would go like, oh, hydro flask, because they've done a really good job at kind of building that. And I think with fashion and with these like any kind of really visually based industry, there's a lot of opportunities for what are called like non-traditional trademarks. And you can go and specifically trade dress. So when we talk about on non-traditional trademarks, you can trademark a color, you can trademark a sound, you can trademark a smell. But in fashion, especially, there's a lot of opportunities to kind of trademark visual elements of designs that are used consistently and serve as signifiers of source. So the most famous examples of these, I think, remember in the early 2000s how maybe it was just for me, but I feel like the stitching on the pockets of denim jeans was always such a strong signifier of source. Now, it's not necessarily their logo and it's not necessarily their brand name, but you could see the like True Religion horseshoe, or I was in like high school at the time. So you can see on the pockets, like, oh, if their jeans are from Abercrombie or whatever it was, that's such a good example. Or for example, Louboutin, they always do the red sole in that specific shade of red. So they've gone ahead and trademarked that. And I think it's fun to think outside of the box and really like pick out the elements of your brand that can be trademarked. I think my job as an attorney, if someone comes to me and says, I have this brand, this is the name, I want to trademark it, like I have to understand like that might be where their knowledge ends, is like that they can only trademark the name. But my job is kind of to educate people and give them the option to have more of like a comprehensive view of what they can really protect and kind of build like this really strong portfolio or like this really strong brick. I don't know. I kind of see IP protection as like a fortress or a wall, and each trademark you get is like a brick that protects it. And there's really so much more that you can do with it, especially in the fashion and apparel space, which makes it really fun.
If you would have had a multiple test and I was just guessing and you said, can you trademark a color? I'd say no. So that was really interesting. I wouldn't have
Yeah.
thought again. We got a question and this actually goes across a lot of different platforms. In this case, they had a mobile hair salon and they had somebody create one of those wraps, on a car, and they
Yeah.
created an image with a woman in big hair. And the company that did it said, hey, this is your trademark, you own that. I don't think I mean, yeah, you owned it, you bought the wrap, but that doesn't mean somebody else could have come not and done it, or because it was original artwork. How does that work? And I know there's a gray area, so we don't want to get in specific, but more so, Nadine, like for when people are buying these things from other people, I buy this wrap, I buy this logo. What do entrepreneurs need to make sure they ask questions? So I don't want you to comment on whether they own that or not. That would be improper and out of context, but more not letting entrepreneurs being gullible and asking the correct questions when they're buying these kind of products and services from people.
Yeah, so I think in the example you just mentioned, I would, in anytime I'm working with a freelancer who is designing anything for my brand, I would want to make sure that if it's like something that I'm going to want to use repeatedly, that, you know, I have the right to do that, that I have the right to kind of reproduce it. If it's the wrap and I want to, you know, print it on my business card or put the same image on my website, I want to make sure that they're allowing me to do that, that I have the copyright or at least the carve out those rights for myself to use it however I want. Just because something is like, you have like, let's say a woman doing hair on the car wrap, it doesn't mean that's your trademark. You would have to, you know, use that same image of the woman across many different platforms to signify you as the source. So something that comes to mind is Skinny Girl, and how she had that like logo that was a woman holding like a martini or whatever. And you saw that so often that you associated it with the mark. But if it was like a one and done, then that's not going to meet the standard.
That's fascinating. That's fascinating. So in that, you know, it makes me wonder, are services ever trademarked? Can somebody trademark something with a service? Yeah,
Yeah,
tell us about that.
absolutely.
Okay.
Absolutely. So we have the 45 international classes. I think 1 through 35 denote goods, and then the last 10 are all services. So I have a trademark for my legal firm. We only provide services. We don't sell any goods. And yeah, like having a hair salon or anything that you can sell in commerce should have a corresponding trademark.
Okay, gotcha. So I got two things that I want to make sure we get into your website before we leave, but one more question. So I feel like entrepreneurs are preyed upon by a lot of companies trying to sell them, well, we'll incorporate your business. We'll do this. We'll do this. I also see, and I'm not wanting to say a name to speak good or bad about them, but just to communicate, LegalZoom's offering trademark stuff as well now. So when an entrepreneur is choosing to trademark something and, you know, going and looking through all the Googles of people that come up that offer that service, what should they be looking for? I mean, I got to believe that LegalZoom probably does the same thing it does with setting up legal structures. It's filing the paper, but it's
Yeah.
not offering counsel. So I'll leave it at
Yeah.
that for you to take it from there.
Exactly. I think, you know, LegalZoom is a paperwork filing service. It's
Right.
not a legal service because, like you said, they can't really give you feedback. It's just going to take whatever input you give it and feed it into the filing system. And then whatever happens, happens. I think as an attorney, like if you come to me with a certain brand name, I can tell you off the bat, like this name doesn't have any chance of getting trademarked because it's generic or because it's too descriptive. LegalZoom will just take whatever you give it and put it out. And, you know, you're saving money on that one application. If it goes through, that's awesome. But a lot of times you might have to, you know, it might get rejected and you have no idea why. And then you have to see an actual attorney. And in the end, you didn't save any money at all. I think, you know, the best thing to do for an entrepreneur and like to kind of discern what they need and what can wait is to just do your own research. Like you talked about, you know, people think the first thing you need to do is get an LLC, or, you know, a name pops into your head and you need to trademark it. Well, now we know you can't actually trademark it unless you are using it or have a intent to use it in the near future. Same thing with an LLC. Like, do you know what it does? Do you know the point of it? The point is to limit your personal liability. So let's say you have an in-person facility and someone slips and falls, or someone gets hurt, or it's a restaurant and someone's exposed to an allergen and they sue you, without a business structure like an LLC, they can come after your personal assets. Whereas when you have the LLC, they're capped at the company's assets, which protects you as a person. And so if you think like, oh, I just need an LLC to have one, but really you don't have a business structure that's really opening you up to much risk, that's something that can wait. So to just like know and build your own knowledge and do your own research and build discernment, or hiring an attorney if you don't want to do your own research, who you can ask all of your questions to. Um, that's going to help you, because sometimes LegalZoom does work. Like if you have an extremely unique and creative brand name, you can just use LegalZoom, and a lot of times it'll be fine, but you don't know that.
Right. You don't know that. That was beautifully said. Beautifully said. So before we leave, I want to make sure that people understand how to get in touch with you, which Sadie's been putting in your website. You also have a free brochure, I'm just going to say, and you say exactly what it is on your website. Tell us, what is the free download? That's the word I should use. What is
Yeah.
the free download, and how do people get in touch with you? And if somebody wants to talk with you about just possibly hiring you, how's that process? So people kind of know
Yeah.
what the process is to get involved with you.
So the best way is Sadie's putting my information. So if you want to like work with me or get the free download, go to my website. It has a lot of information on it. And if you scroll all the way to the bottom of the homepage, you can get the free, it's a brand protection guide. It's very much geared towards fashion and apparel entrepreneurs. But like we've been saying, everything in trademarks pretty much is widely applicable. So no matter what you have, there's going to be information in there that is, you know, applicable across the board. And you can kind of see based on the examples I give what's what. So no matter what kind of business you have, just go ahead and download it. I'm sure you'll learn something. If you want to reach out, there's a contact tab, and it'll go straight to my email, or an email that I check. So you can ask me any question. We can talk about setting up a consultation. And if you want to follow me on TikTok or Instagram, I am working on being much more consistent on those platforms. So that's another way to stay in touch. And I also post a lot of like informative educational stuff on my social media as well.
This has been fascinating, so informative, so educational. I have learned a ton. I can't thank you enough for coming on. And I want to, end by also saying, I keep telling people that there's certain things, in my opinion, are not DIY when it comes to business. I think marketing, all that can be DIY, absolutely. But when you're talking about legal, when you're talking about finance and tax, it's not DIY.
Yeah.
And LegalZoom is a lot of times, really is just DIY. So what I want to say is, I think our conversation once again proved that to me, because I sure learned a ton about trademarks and the importance of having a lawyer that understands the background of getting a trademark. So with that, I'm going to bring Sadie back on. Do you just feel like we learned a ton today, Sadie?
I mean, it's like I get it in the sense of why you were so like, I got a lawyer, I got a lawyer. Cause I was like, oh my God, I'm like, like we went on some other journey today. I think we got a sneak preview of Ask an Expert, on my honest opinion.
We did, and we know we're going to ask Nadine to be one of our first guests on the Ask an Expert, because
I
we're
would
going
love
to
to.
really get it. All we're going to do is talk about, the information and do more of that. So anyway, Nadine, thank you for being the first lawyer to come on. Now it just makes me want to have more lawyers on, because there's such a great opportunity to have a discussion about the things that everybody is just asking Chat GPT. I'd rather have them actually talk to an expert and have
Yeah.
this kind of discussion. So thank you for giving us a
Yeah.
platform.
Another thing to say, even when using ChatGPT, you know, when you're asking legal things, you need to have discernment, because ChatGPT is kind of trained to affirm whatever it thinks you want it to hear. So it can, I mean, I've asked it to pull like case examples or examples of previous trademarks, and it'll give me like a reference number that doesn't exist. So be careful with ChatGPT as well.
And I will not use, it just always astounds me that people will use Chat GPT for finance, legal, tax. To me, it's just, that's not appropriate. But
Yeah.
that's because when you're in the industry and you're an expert, you understand what it's not, what it's not made for. So thank you again, Nadine, for coming on. Everybody, Sadie's going to stay behind so she can make sure you get Nadine's information, my information, anything you need. I know the conversation's still going on in the chat. And by the way, Nadine, you're getting a ton of thanks for today. They love
Oh,
the
of
show.
course.
So if you take a look at the chat box, you're getting a lot of thanks for coming on today.
Of
So with
course.
that, guys, we don't have any more time. So I want to thank our frequent flyers for being here every single week. If you were new, make sure you tune in again. We always have an exciting show here. And so I want to say thank you for watching Small Biz Talk with your host, Lori Williams. Thank you again, Nadine. And I'll see everybody next week. Bye-bye.
Bye.
Bye.
Thank you.